Mr. Davies, good morning to you today, sir. Good to see you. You may proceed.
May it please the court. I'm Wade Davies, and Georgia Miller and I represent Desmon Rhea. I'd like to reserve 5 minutes for rebuttal. At the final closing argument in this hotly contested case, Assistant District Attorney Williams falsely told the jury that he and the state represented Desmon Rhea and that they were only people who were pursuing the truth. And that was false, because if it had been true, he wouldn't have gone on to also falsely claim that Desmon Rhea killed a victim with her 6-year-old granddaughter in the bed with her. And I want to make something very clear, because this is something that I would normally not say about a colleague, but the record shows that this was an intentional misstatement. And he said, he shoots Mimi while she's lying there sleeping with her granddaughter. I objected to that as being false. The judge didn't rule, he just said this is final argument. It is very interesting that the state's brief in this case at page 43 does not address the intentionality of the false statement in the case. All it says is there was an inference because there was a doll in the room. Well, there were first of all, toys all over the house. But the reason that it's false is because this matter had been litigated for a long time, and everyone knew what the record was. So the 6-year-old child had been interviewed in a forensic interview. I had challenged the admissibility of the interview. I had it transcribed. It was in the record. Everyone had seen it. And the child had specifically stated that she was not in the room when this occurred. We also had a hearing on a destruction of evidence in which Investigator Booker testified about his interview with the child, and he said she did not see what happened. She was not in the room. So when Williams made that argument, he absolutely knew that it was false. The argument that there was a doll in the room would be like me saying that, and looking you in the eye and saying, I am not present here today because my briefcase is back in my office. It's not a matter of an inference. It was a matter of a statement that he intentionally made to the jury because it was inflammatory and false. So the state never made any attempt in the motion for a new trial when I raised this issue, or when I asked for a mistrial, to have Mr. Williams explain that he had some kind of different evidence or anything like that. They had the child there. She was on the witness list. They ended up electing not to call her, but this was not an error. And if the state was pursuing the truth and representing the interest of Mr. Rhea, the prosecutor wouldn't have also claimed in closing argument that there was no Ferguson violation, that the state didn't have a duty to maintain the crime scene, this car that they gave away. It was just untrue. The judge had ruled there was a duty. The judge had ruled there was a Ferguson violation. Right before we did the argument, we talked about what arguments would be acceptable about Ferguson.
Did the state actually concede there was a Ferguson
Yes.
violation, and the only question was the remedy, right?
Right.
Okay.
Yeah. There was no question about it. And we talked about what was going to be argued about Ferguson right before final argument. Judge Green told the state that it could respond if they thought I went overboard on the inference, on the inference in favor of Mr. Ray. Not that they didn't have any duty to preserve the car. And the other thing that he said was, this wasn't important because I had waited a year to ask to see the car. This is also something that is false in the record because they gave away the car before I was ever appointed in the case. They gave away the car in June of 2020. I was appointed in November of 2020. It's in the record. One of the first things that I did was to file a specific discovery request asking to see the car. I explained why, because I wanted to see if there was blood in the car. And so, that, again, that's just totally false. The state appears to say, with regard to the Ferguson argument, that there's no precedent that this was an improper argument. There is precedent that you cannot make a knowingly false argument to the jury, and the precedent was the Judge Green had told them what they were allowed to argue, and the prosecutor just disregarded the instruction.
So, Mr. Davies, in the brief, the defendant's brief identifies a number of issues that it takes with the closing argument, only some of which were objected to at the trial. Some of them also were identified in the motion for the mistrial, some additional ones as well. The Ferguson issue that you've raised, was that the subject of any objection or on the mistrial at all?
I don't think so. I think I asked for a mistrial about closing argument. I don't believe that, I can't remember mentioning the Ferguson argument.
How would you ask us to handle issues then when we have maybe a list of issues with closing argument, some of which were addressed by way of objection, either during the hearing or at the motion for a new trial, and then others that simply aren't there? Are you offering those just to show context about how harmful the argument is generally, or are you asking us to conduct a plain error review? I mean, how are you asking us to resolve that situation where some significant portion of the complaints were not the subject of an objection?
Right. Well, I think I objected 4 different times during the span of a 30-page argument.
It looks to me like there are 7 issues at issue that have some objection to.
I think that's right. I went through and counted them. So I also asked for a mistrial. The Ferguson issue, I think, was addressed by the court before argument. So I think it was addressed. It is addressed by the trial court before he made the improper argument. I didn't object again.
Sure.
Because I think the court had already ruled. I think a couple of things. One is that I couldn't just object to the whole thing. And the one reason is the court wasn't actually ruling on my objections. The court was just saying, this is argument. So it didn't do me any good to keep objecting over and over. The other thing is that when the defendant has established improper argument, I think under State versus Goltz, the Tennessee criminal appeals case from 2003, I think the court looks at the entire argument to determine whether there is reversible error in the argument. Because in the Goltz case, the court mentioned that there were a couple of objections that were sustained, but the prosecutor kept on making an improper argument, and so it looked at those things where there was no objection as well. So I think the court just looks at the entire argument once we've established that there was improper argument.
Mr. Davies, the Tennessee Supreme Court has cases indicating that it's rare that we would reverse a jury's verdict based upon the closing argument alone. Are there reasons in this case that you believe would warrant reversal on the closing argument?
Absolutely.
And what are those, please?
Because I think the state's argument violated just about every factor that the court looks at. So if there is an intentional misstatement, the court would be more likely to reverse it. Expressing personal beliefs, inflaming or attempting to inflame the passions or prejudice of the jury. I'm talking about a 6-year-old child being right next to someone who was shot falsely. and arguing or referring to facts outside the record. So the other reason is that there were the two most important issues in this case were hotly contested. And this is not a harmless error situation. So there was a real question about what happened, about who had fired, who had shot. The only person that the state had saying that Desmond Ray fired the gun in the car was Whitson. Whitson is the one who had gunshot residue on his hands. And when I asked him, the very first question I asked him on cross-examination was, did you fire a gun on March 8th, 2000? And he goes, He just sat there. So there was a real question about what happened, and there was a real question about Mr. Ray's mental state. So it's not a harmless error situation, and I think that is the reason that this court should reverse based on this intentionally improper, inflammatory argument.
Before you move on, just real quick, you had mentioned that the trial court didn't really rule and just said this is our argument. And I think what he said was, told the jury that if something the lawyer says is different than what you heard from the evidence, you go with what you heard from the evidence. In light of the fact that a trial court cannot comment on the facts, what should this trial judge have done when, for instance, you objected to the child wasn't actually laying next to her?
He should have granted a mistrial, but he should have at least stricken told the jury to disregard that argument.
And that's not a comment on the facts?
It wouldn't be I don't think it's a comment on the facts to instruct a prosecutor not to make a false argument and to disregard something in which there is no proof in the record. I mean, that is an egregious situation, one I don't really see come up very much, where there's an intentionally false statement. I mean, it's one thing to say, refer to your recollection of what the testimony was. This is a little bit different situation where this prosecutor knows what the facts are and says something that is false. So that's a little bit more egregious.
Move on to your next issue. Thanks.
All right. I better move on to at least mention the mental health issue. And as the court knows, when Mr. Ray was arrested, he was interrogated for a long time. He was obviously seriously mentally ill. He had psychosis, meth-induced psychosis. He made a number of statements, including incriminating statements, and he asked for an attorney very clearly. When he asked for his attorney, the investigator said, that's not how it works, bud. Went on, interrogated him more. Mr. Ray made statements that were very odd, but they were incriminating, and Judge Green suppressed those statements. I filed a motion to ensure that those statements that were taken in violation of Mr. Ray's right to counsel wouldn't be used when we put on our expert about meth-induced psychosis. The judge ruled very clearly that if we put the expert on, anything that he relied on is fair game. And I think that was error, and I think under just the rules of expert testimony, that was error. It happens all the time in a situation where there is a psychological or mental health expert where that person, for example, has done a compelled examination of the defendant. The expert is not allowed to talk about the statements that the defendant made if they were confessions during that time. So it's not unusual for an expert to be able to testify without directly referencing certain statements, and that's what we propose to do. Dr. Lippman said that he could do that without referring to the substance of Mr. Ray's statements, and that is what should have happened. So,
but under the rules of evidence, though, under Rule 705, wouldn't that information come in under cross-examination? It would not come in under 703, admittedly, as the proponent of the evidence. So if the state is offering the proof, That doesn't come in under 703, but under 705, it looks like under cross-examination it would if it were a fact relied upon by the expert to reach the conclusion.
Because the expert would say he is not relying on whether there was a confession, whether there's an admission or not. He explained that what he was relying on is Mr. Ray's demeanor, the way he was making the statements, the paranoid things that he was expressing, and so forth. So he could have easily expressed that opinion, regardless of whether Mr. Ray said, I shot someone or I didn't shoot someone.
Okay. Mr. Davies, thank you very much. Thank you. General Coleman, good morning.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments for a variety of reasons, but ultimately the trial court made no errors and the evidence was sufficient. My friend on the other side has focused on two principal arguments here. If this court has questions about any other issues raised in the brief, I'll happily answer them. Otherwise, the state will also rely on its brief for those issues. But turning to the first issue with regards to alleged improper closing argument, I think, three potential statements that were presented to this court today. Two of those were waived. The claim that the complaint that the state explained that it represented everyone in the state and that it was pursuing the truth was not objected to at closing argument. And to your question, Judge Greenholtz, this court has to interpret these differently pursuant to Enix and Vance and all of the Tennessee Supreme Court precedent that mandate a contemporaneous objection. I think my friend on the other side today said that he couldn't object throughout, and I don't understand why not. If the state made objectionable comments, the defendant has the obligation of contemporaneously objecting to each of those comments to preserve those issues on appeal. So he did object to 4 different statements. Those are properly preserved for review. Every other statement that was not objected to was waived and is at best subject to plain error review. As an initial matter, the defendant has not requested plain error review of any of those or performed a plain error analysis. And so this court should simply decline to conduct a review at all, even if it conducts a plain error review. With regards to this representing
What I hear your friend on the other side suggesting, though, is that upon a finding that there were intentional misstatements that were preserved in the record, that to analyze the harmfulness of that, we would look to the argument as a whole. And if we look to the argument as a whole, we'll find other examples of misconduct, such as purposefully misstating, relying on facts outside of the record, appeals to a motion to the jury, and that we have a properly preserved objection, in fact, a motion for a mistrial as a result of the argument itself. What's your response to that?
So 2 points. First, the state would submit, and I'll discuss why it wasn't an improper argument at all. Secondly, even when you do what Gold says is you look at the context of the closing argument. I don't think that enables this court to conduct independent analyses of the separate statements in the closing argument. Instead, you're saying, how was this allegedly improper statement taken in context with the entirety of the argument? Was it so bad and so improper that it warrants reversal? Not, was this, now that we're looking at the context, we're going to analyze other issues, other statements that were not objected to, and sort of make an independent analysis of them and then do accumulation. I don't think that's what GOLTS stands for. And so I guess I'll go to the first point here is the objection that was properly preserved does not amount to improper closing argument. My friend references a forensic interview and I think an officer's statement. The record will be more accurate than my recollection. I don't think either of those are in the record on appeal, period. What they certainly weren't is in the trial. And so at trial, what we have is proof that this minor victim, one of the minor victims, lived with the other individuals. We have photographic evidence, and I think the defendant sort of downplays it and says there was a doll. That's not what this is. And when this court looks at the record, particularly exhibits 82 through 85, I believe, it will see the room in question. And yes, half of the room is dolls. It is clearly a child's room that a child is sharing. More importantly, there are photographs of the bed. And the way the bed is arranged is it's pretty clear that there are 2 individuals who are staying on this bed. The victim, one of the murder victims, is on one side of the bed. The other side of the bed has rumpled sheets, has a separate pillow, and that is where a doll is. And then I think on top of that, the fact that the minor victim, who was the victim of aggravated child endangerment, or I believe that's what the charge was in the house at the time. When police responded, they found that victim in the house. All of these facts together allow a rational inference that the victim was in the bed, or the victim was there at the time of this shooting.
But for the forensic interview, and you're disregarding that because you say that forensic interview or the facts that it contained therein are nowhere to be found in this record?
I'm unaware of it. I do not recall. Again,
Because that's a big distinction. If the prosecutor knows of affirmative evidence outside what was presented at trial, but he knows that this statement was made, you would agree that it would be inappropriate for that prosecutor to make the argument that he made at this trial?
That would certainly be a problem. I have never heard of this forensic interviewer officer statement before. The defendant didn't, I don't believe, refer to it in his brief. I'm unaware of seeing it in the record. The record is pretty voluminous, so it might be in there. I don't recall it. And I think it is, based on what I recall from the record and the arguments and the objection made at the time of trial, there was no "Judge, he's lying to the court." It was just objection. This isn't facts in the record. There's no proof that she was sleeping in the bed.
Your friend on the other side also suggested that the child made a statement to an officer, though separate from the forensic interview. And so if the forensic view plus statement to the officer is there, that also seems to reflect negatively upon the argument.
And again, Your Honors, I would just submit that based on the proof that I can recall from the record, I don't remember either of those things. And so we would submit that that was a proper inference from the proof that was presented at trial. But even if this court has issues with that, none of the other objections, none of the other alleged improper closing arguments were improper. And then when you're looking at Goltz in context of everything, this one statement wasn't so egregious, to the extent it was egregious at all, that it warrants a reversal, especially given the significant damning proof of what this defendant did. And I think we have some family members of victims here, and there are people watching, and I do want to take a moment to just focus. I know Your Honors have read the briefs, but I want to focus on exactly what this defendant did.
Before we get there, and I want to hear that too, General, but before we get there, you keep referring to only 4 objections that were made. I thought there were 3 additional statements that the defendant objected to in the motion for mistrial. Why is the state discounting those?
They weren't contemporaneous. I don't recall.
I mean, but they were offered at a time where the trial court could have done something about it.
So pursuant to Enochs and Vance, the objection has to be contemporaneous. So I think it would need to be at the time of the statement itself. To the extent this court disagrees and finds that those other 3 statements were sufficiently preserved, we've provided a sufficient analysis of why they didn't amount to. I think we discuss it in the context of clear and unequivocal rule of law being breached, but it certainly doesn't rise to the level of improper closing argument.
Okay, my apologies.
What about the argument regarding the state's duty to keep the car? Because I believe you're saying that falls under the category of one where there was no objection, but I hear Mr. Davies saying, well, I didn't really need to because we discussed this right before argument and he was instructed not to go there. So what do you say about that one?
So I think the context, I'm trying to find exactly what the state said, but the issue that Ray takes up on appeal is the state saying that there's no duty for it to preserve this issue or preserve the car indefinitely. And that's just an accurate statement of the law to the extent that the state provided that additional context. And
I think what I understood from Mr. Davies was that the objectionable statement was that defense counsel didn't request to see the car until a year after he had been into the case.
So
but that wasn't the case, that Mr. Davies hadn't been retained by that point.
the statement at issue on record 35, or volume 35, page 1530, was the state is not required to indefinitely keep that car. It was over a year from the time they collected it before the defendant even asked to look at it. If it's so important to look at it, why wasn't it done? And then the state contextualized that to say any proof about the car is in favor of the defendant. The defendant successfully obtained a Ferguson instruction where the jury could presume this missing evidence would have been favorable to him, and the state highlighted the car was seized. It was processed. Items were collected from the car. It was processed for blood, for DNA. There's just no blood in it. So when you take the entirety of that statement it certainly doesn't rise to the level of improper closing argument. It's not misstating the evidence. It's not inflaming the jury's passions. It's not doing any of the Golds factors. It's saying we didn't have to keep the car indefinitely, but it doesn't matter because there's no blood.
When was the car released? How soon after processing?
I believe it was a year after it was collected. And again, I think my friend on the other side is correct. He wasn't appointed until a significant time after the charges were initiated. And so I don't know the exact time frame between when he was appointed and when it was released.
Was proof presented at trial as to when defense counsel requested the car or the examination of the car?
There are emails to that effect, right?
There might be emails. I don't know if they were presented at trial. I do think that an officer sort of fell on his sword or explained, that we never meant to get rid of this so quickly, but instead, what happened was an officer confused this white sedan with a different white sedan and released it erroneously, a different officer in a different case. And so I think that was presented at trial of, we just erroneously released this car when we shouldn't have.
Did I understand the prosecutor to argue to the jury that he referenced when Mr. Davies had requested to see the car?
I don't know if he referenced when Mr. Davies had. I think he said we had the car for over a year, and no one ever asked to look at it. So it wasn't necessarily faulting Mr. Davies, but just in general, we held this car for a year. But then contextualizing this, none of this matters because the whole point is, there might have been blood, there might have been DNA, and we're admitting that there was no blood in this car. So do the Ferguson instruction and infer that this evidence was in favor of the defendant. And at that point, that cannot rise to the level of plain error or to improper closing argument.
If the court finds that there is error, maybe even substantial error in the closing argument, how is it harmless?
Given the overwhelming proof, thank you, Your Honor. To get back to that, I wanted to point out what the proof was and what this defendant did. So in March of 2020, Ray shot and killed first Miss Julia White in her car, and he dumped her body on the side of the road. And there was an eyewitness who testified that he saw that and exactly what happened. After he murdered Miss White, he drove back to her house, which was a 2-story split foyer building. He killed Miss White's mother, Mildred Blackwell, and he also killed another resident of the house, Barbara Rogers, in upstairs buildings. There were 3 witnesses to that. No one actually saw the physical shooting, but I think my friend said there's no real question about what happened, or that there is a real question about what happened, and that's simply wrong.
Is Whitson the witness that you refer to who saw the body being dumped?
Mr. Whitson, yes, he was an eyewitness to the shooting in the car and saw the body being dumped. He and 2 other individuals who I think at least one of them testified were at the house because Mr. Whitson returned to the house with the defendant, and 2 others had been sort of chilling there the whole day, and all 3 of them saw the defendant or heard the defendant go upstairs and fire multiple shots, come back downstairs acting in a certain way. Heard him go back upstairs and say, "Oh, you're still alive," and fire another shot. So after he's committed these murders, then Ray fled the scene again with Mr. Whitson. He dumped the gun. He tried to have someone get rid of Miss White's car, and he instructed Mr. Whitson to sort of cover his tracks and cover your hands when you're touching the car and things of that nature. So the evidence, again, the state sort of frequently says overwhelming proof, and sometimes that's a misnomer. But here, the evidence significantly weighed against the defendant and showed that he was guilty. And so, even if this court finds that any of the comments at issue in closing argument were erroneous or improper, when you take it in context of this significant proof, a reversal is not warranted. Turning briefly to the second issue that was presented, unless this court has questions. The second issue that was presented was that Ray claims he was denied his right to present a defense. And to provide some context, he did successfully move to suppress statements that he made to police. What the trial court found was these were voluntary statements, but they were taken in violation of Miranda because he invoked his right to counsel. And so after that, he filed a pretrial notice of intent to call a mental health expert, and the court found that the expert could testify. So he didn't exclude any information or didn't prevent Ray from presenting any information. Instead, he said, if this expert testifies, the state is allowed to cross-examine him on any of the things that he considered in making his determination. Ray made the tactical decision not to call the expert. At no point did he claim that this violated his right to present a defense, and then now he insists that it violated that right. So he's wrong for a number of reasons. First, this court can simply find that he waived this claim by failing to raise it until his motion for new trial. Again, he had to contemporaneously present that to the court so the court could make some analysis. He waived it by failing to present it until his motion for new trial. And I think it's more than that. It's almost an invited error, because when he asked the court, have you decided about whether the state can cross-examine on these formally suppressed statements, and the court said, no, they're fair game on cross-examination, he stated that he appreciated getting the clarity. So he didn't even object at that point. He said, okay, now I understand. So it's waived. Secondly, the denial of right to present a defense focuses on the exclusion of evidence. The court here did not exclude any information. Instead, it presented defense counsel with a strategic decision of whether to present evidence and face the consequences or not to present that. So the court never excluded it. It just said, here are the collateral consequences if you choose to do that. And this court has repeatedly held that does not violate the right to present a defense. Instead, it just presents counsel with strategic decisions on how to present their defense. And then finally, the ruling just did not deny the ability to present a defense because it was a proper determination by the court. I don't want to belabor this issue. I think it's pretty straightforward, and there are 3 different ways that this court can find that it is without merit.
Your friend on the other side suggests that Rule 705 would not allow it on would not allow that testimony to come out on cross-examination. What's the state's view?
I think it would, and I think it might even come under 703, because 703 deals with a probative versus prejudicial analysis.
Well, but at that point, though, I mean, we're talking about the proponent of the evidence offering it, and the defendant wouldn't be offering that.
Then under that situation, then 705 would apply. I don't have the rule directly in front of me, but I know that this court and the rules of evidence allow for cross-examination of an expert on the basis of their determination. And so I think that would just be fair game here, even if this court didn't want to get into the Miranda sort of rabbit hole. Okay. It was just a proper analysis. I recognize I'm sort of the only thing standing between this court and lunch. Unless this court has further questions, we ask that you affirm the judgments. Thank you.
Very good. Thank you. Mr. Davis, 5 minutes.
I'm still sort of amazed that the state maintains the position that falsely stating that a 6-year-old was in bed with the victim was fair game. In terms of the record, the child's statement, forensic statement, is in the record. I put it in the record when I moved to exclude the statement. It's in there. It's Supplemental Record, Volume 3, Exhibit 1. It's stated at page 10 of the reply brief. I have transcribed the statements. I put them in a motion, which is in the record. So the argument that it's not in the record is just wrong. In terms of the other points of argument, some of the statements that were made about the Ferguson violation are also just based on a factual misunderstanding. So what happened with the car, it wasn't a similar car. The officer thought got confused between a Jeep and the Sentra, but they gave that thing away a month after they had it. So it was given, the incident was in May of 2020. It was given away in June. I was appointed in November. I immediately filed a discovery request asking to see the car. I didn't know what had happened. I mean, you can see, I asked multiple times over the course of a year to see it, and it wasn't until maybe a year later they admitted that it was given away. But it was given away way before that.
Can I
the
ask?
Reason that,
I'm sorry, sticking with the car for a moment. The court gave the 4210 instruction. You can draw inferences against the state for losing it, but They didn't have to do that because the proof came in that there was no blood in the car, and you made use of that in trial. Does that not remove any prejudice?
No, because the prosecutor argued that Desmond Ray had plenty of time to clean out the car. They also tried to put in a preliminary blood test result indicating that there was blood in the car, even though the TBI test said that the substance wasn't blood. They put it into evidence anyway. So there was an argument that there had been blood in the car and that Desmond Ray had cleaned it out. So I needed to have an expert inspect that car, and it wasn't able to do that. It was not just in favor of Desmond Ray that they lost the car. The state still argued that there probably had been blood, that he had plenty of time to clean it out, even though there was no evidence to support that. So there was the email requests to see the car weren't put into evidence at trial because there was no reason, because the court had already found that there was a Ferguson violation. There was no reason for us to be litigating that. There had been a finding, and then the prosecutor just disregarded the finding in his closing argument. I want to turn up to the mental health issue, especially with the argument on waiver, because you can see from the record, I pretty much argued this issue. If I had argued it any more, I probably would have been held in contempt. Finally, Judge Green said to me, I wear the robe and this is my decision. So I raised it in 2 different hearings. I filed a motion. I cited the authority that we cite, Edwards and Wainwright. And what I explained is that the problem is that there is no authority that would allow the use of unconstitutionally obtained information to cross-examine an expert. When something is taken in violation of the right to counsel or the Fifth Amendment right to counsel, it is true that the defendant can't come in and say something totally different. The state is allowed to impeach. But that, under James versus Illinois, that doesn't go to any other witness, only the defendant. So I cited the proper constitutional authority, argued the rules of evidence. I informed the court that I needed a ruling on this because it impacted the mental health defense. And so I'm not sure how I really could have raised that anymore. The issue was that it violates the Constitution to use information that was obtained in violation of Mr. Ray's right to counsel. And there was an easy way to allow the expert to testify without that violation.
Did your expert rely upon the statements that had been made, not just the fact of the statements, but the actual statements themselves?
He explained this in an affidavit that I submitted, and he said that what he mainly relied on was I can't remember exactly what he said, but he mainly relied on Mr. Ray's demeanor, his paranoia, the things that he expressed during the interview, but it didn't matter to his opinion whether or not Desmond Ray said, I fired the shots that killed the victims. He didn't rely on that in forming his opinion.
Okay, that's very good. Mr. Davies, thank you very much.
Thank you.
Thank you. General Coleman, thank you. And once again, the court appreciates all of the parties coming here before this December session. It was a well-argued case, and the case is submitted. Thank you. The court will stand in recess to lunch.
Can I tell you something about the courtroom that has nothing to do with the case?
Please.
We were talking about the symbol up there. So in 1992, when I tried my first case in here with Tom Dillard, when the jury was out, he saw me. I was trying to read, let no man talk about sin. It says something about sinews